Welcome to the Workology podcast, where we discuss the science and art of the workplace, gain powerful insights, resources, and perspectives on the industries of human resources and recruiting. Join your host, Jessica Miller-Merrill, chief blogger of bloggingforjobs.com, for an in-depth and no-holds-barred look into the future of our most powerful business asset, the employee. And now, welcome your host, Jessica, with this podcast episode of Workology.
The Fair Labor Standards Act changes and rulings have finally come down. And so now I think the human resources industry can take a deep breath because we know what the new expectations are. However, we need to understand what those expectations are specifically and how we address them in our workplaces. And most importantly, communicate them to our employees, but also senior management. That's what we're going to talk about today, what employers need to know about the FLSA changes. Welcome to the Workology podcast. Our guest today is Casey Sipe. Casey is a management-side labor and employment attorney with Caldwell & Kearns in Harrisburg, Pennsylvania. He writes about labor and employment on his blog, The Employer's Lawyer, and he's also a contributing writer over on Blogging for Jobs. Casey's been on the podcast 2 or 3 times about different topics, and I'm glad to have you back again, Casey. Welcome.
Thanks for having me.
Awesome. So let's get right to it. Today, as I said, we're talking about the Department of Labor's final rule on the updates regarding the Fair Labor Standards Act, or the FLSA. This new announcement provides a much-needed update surrounding 4 key areas. 1, defining and delimiting the exemption for executives. 2, administrative. 3, professionals. And 4, outside sales and computer employees. Just to give you some background, the Department of Labor published a notice of proposed rulemaking in the Federal Register on July 6, 2015, and invited interested parties to submit written comments on the proposed ruling until September 4th, 2015, which we've had a couple podcasts like in the interim and articles on the blog talking about those things. The department received over 270,000 comments in response to the sort of open invite. They're from a variety of people from all across the working world here in the United States. The feedback the department received was helpful and helped shape the final rule. So let's just kind of get to it and talk about it as it was outlined by the DOL. All right, so let's start talking about it. Can you run us through the changes that are going to be happening, Casey? Give us a download.
Sure. So the biggest one is that they're changing the minimum salary requirement for an employee to be considered exempt from overtime and minimum wage. So prior to this, it was fairly low. I believe is $23,000 and change. The new number is $47,476 annually for a full-time worker. It breaks down to $913 per week. So in other words, if your employees are not making more than $913 per week, they can't be considered exempt from overtime or minimum wage, regardless of what their job duties are. So I'm sure you can do the math, but that's more than doubling what the minimum salary requirement has to be. The second big change is that there's an exemption called the highly compensated employees exemption. That was previously set at $100,000. So if an employee is making $100,000 and was undertaking certain duties, they were also exempt. That amount has been raised to $134,004. So both of these numbers, the 47,476 and the 134,000, are now going to be tied to the 40th percentile of earnings for full-time salaried workers in the lowest wage census region. So currently that's the South, although that could change. These numbers will be updated every 3 years starting in 2020. So that's really important because the big reason that we've had this huge jump is that they're updating numbers that were set back in the 70s. So anybody who's been paying any attention since then knows that inflation has gone way up, and that $23,000 a year is not nearly what it was back then. So that's the big part of it. There's also a smaller change that has to do with what you can count as your minimum as the employee's salary, because there was some question about including bonuses and that sort of thing. So what they did was they said that if you have a non-discretionary bonus or an incentive payment, that it can count for up to 10% of the minimum salary. So under the current numbers, that means that $4,747.60 of whatever bonus can be counted towards the $47,000 minimum salary.
Casey, let's talk about things that HR and business leaders need to be most concerned about. What are those things?
So I think there are a couple of concerns that are really top of mind here. One is the difficulty in implementing this, because you're going to be taking people who were salaried under the old rules and now they're going to be hourly, which means they're going to have to start tracking their hours. They're not going to be able to do work off the clock. So if you had somebody who previously was salaried, they didn't need to keep track of when they were in and when they were out. They didn't need to worry about snow days. They could take work home and do work at home if they wanted to. They could answer emails at home, all of those things. And all of that is going to have to go away under these new rules unless the employer wants to pay for overtime. The second big issue is going to be morale. You're going to have a lot of employees who held onto this exempt status as something of a symbol of their progress. So they're going to be possibly a little demoralized by the fact that they're going, quote unquote, back to being an hourly employee. So you have to figure out the best way to move these people to communicate the change. And the third thing is purely economic. How are you going to fit this in? There are a couple of different options for handling it, but you're going to have to figure out which ones are going to work best for your business, because if you just keep moving forward the way that things are now, you're going to end up with a fairly large overtime bill, I'd imagine. And that's never going to be good for the bottom line.
Or a lot of Department of Labor charges or investigations because you might not have made any changes at all.
Right. Yeah. And that's another good point, because it is important that you follow through and implement these changes, because sooner or later the Department of Labor is going to come knocking, whether it's by happenstance or because one of your employees saw an article online or heard something on the news. And this is getting a fair amount of play in the media for something as dry as overtime rules. So you can bet that more employees are aware of their overtime rights than ever before.
I would say, just as a side note, I've seen the unions be really involved in this. In fact, I'm involved in another text message notifications by union organizations. So I get these texts, and a lot of them were calling for comments and employees to leave notes for the open comment period. So you can rest assured that your local union organization will be actively communicating and sharing information around this. So if you aren't doing it, they will be.
Right. And I mean, at this point, I mean, here's a quick little PSA. Now is the time to take stock of your wage and hour procedures. Go through everything you have and make sure that your employees are being properly classified. This is the perfect time to swap over people that are improperly classified, because one, it's not going to set off a big red flashing light to them that they weren't being paid properly. You can just simply say, we're swapping you over to hourly now under these new rules. And you can sort of use that as a way to smoothly move in. The other thing is, like I said, you have more employees than ever who are going to be aware of their overtime rights. And the last thing that you want is for them to start asking questions and realizing that maybe they're not being paid properly, because the penalties for this sort of thing are fairly steep. I mean, they can get back pay up to 3 years. So if you've got an employee who's working, 10 extra hours of overtime per week for 3 years, it's not hard to get above $50,000, $60,000, $70,000, and then multiply that by all the employees in their class. And pretty soon you're talking about some real money.
Yeah, and I think the Department of Labor is going to look at this as an opportunity to generate some revenue eventually.
Agreed. Yes. Yeah, because they'll come fining and everything else, not to mention the legal fees that you'll incur in having to pay someone like me to defend you.
Well, let's talk about when all these changes are supposed to start and then maybe some steps for HR professionals or business owners to, to start doing now in preparation.
Sure. So the regulations go into effect December 1st of 2016. That was pretty recently announced in the last 2 weeks or 3 weeks, I suppose. And so that is the hard and fast, implementation time. So if you're not compliant by that point, you will be violating the law. So the big thing is to use the time that you have right now. So you've got about 5 months to figure out what's the best way to move employees from salaried to hourly, how to do it in a way that doesn't destroy morale, how to do it in a way that doesn't completely blow your bottom line. And like I said just a couple of minutes ago, conduct a wage and hour audit, because now is the perfect time for it. Make sure that you're properly paying everybody you have, and then move anybody who is improperly classified over to hourly. And a lot of people will probably think this is a bit of fear mongering, but honestly, you really ought to be doing this with some sort of a counsel, because figuring out who is exempt and who is not exempt is very easy in 80% of the cases. But it's that 20% that is really, really difficult, and it is extremely fact specific. And if you don't know the FLSA requirements cold, you're going to make some mistakes, and they'll be expensive mistakes.
We don't need any more expensive mistakes.
Right.
Well, let's take a little bit of a reset here. This is Jessica Miller-Merrill, and you're listening to the WORKOLOGY podcast powered by Blogging for Jobs. Today's topic is understanding the upcoming Fair Labor Standards Act changes with Casey Sipe. And you can follow Casey on Twitter at CSL Employer Law. All right, so let's get back to it. Obviously, this topic has been covered a lot in the news. We talked about that already. But I feel like there probably hasn't yet been a lot of communication from employers directly to employees. Is there anything we're not allowed to say or that we're required to say to employees about changes?
No, right now. I think it's more of a public relations approach you need to think about at this point. I keep going back to morale, but that's going to be a huge factor in how this ends up working out. So you, of course, will know your workplace, your employees better than anybody, including your lawyer. So you're going to have to be the one that figures out, how do we discuss this with the employees? In some cases, you're going to be, better off holding an all hands on deck meeting and explaining it to everybody. In some cases, you're going to be better off having one-on-one discussions with the people that are going to be affected, so that you can explain it to them. And maybe it's a combination of the two. Maybe you pull some of the key personnel aside, you explain it to them one-on-one, and then you have an all-hands meeting and explain it to everybody else. But figuring out how to accomplish this with the smallest effect on morale possible is going to be a challenge.
And let's think about this, because December 1st is when we need to start implementing these changes. That is the middle of the busy holiday season. And I don't think that employees, it might not resonate with them. And if it's going to impact their salary in such a way when they're planning on purchasing a lot of holiday gifts for family members and friends, we don't want to blindside them. Absolutely.
Although I would say in most cases, whether or not they realize it, the employees are going to be making more money under these new rules. I mean, that's the whole way that the Obama administration is selling this, that this is going to give an additional 5 million people access to overtime pay. So, people who were previously salaried, and it didn't matter if they worked 30 hours or 60 hours, they made the same amount of money. Now, if you have a busy time and you work 60 hours in a week, your paycheck is going to be significantly larger.
That's a lot of money in overtime pay. I understand why the administration would say that because, yeah, if the average person that's salaried works 60 hours a week, then, yeah, they might get a little bump in pay. But, and we'll have to see how when people are evaluating salaries and payroll costs, it might be easier for them just to bring on extra people, part-time or contract workers, into the mix to fill those gaps.
Right, and that's certainly one of the options. One of the other options is to basically look at each employee and say, okay, well, this employee here typically works 50 hours in a week, and you can do some math to figure out if they're working 50 hours and getting 10 hours of overtime, how to pay them an hourly rate that equates to about what they are already making per week in salary. So in that case, the employee is really going to be taking home generally the same amount of money that they already would. The downside for them, of course, is that if they're not working that extra overtime, they're not bringing home the same amount. The downside for the employer is if they have some sort of surge and they need people to work even more, then they're going to be paying out more money. So in the end, a lot of it will probably even out. But certainly the intent is to try and put more money in people's pockets.
Random observation that just popped in my head. I was thinking about the TSA and the recent challenges in Chicago at O'Hare with the long lines, which were as a result of executives or leaders not approving overtime. These are some things we're going to have to think more about because it's going to be more commonplace.
Absolutely. There's, like I said a little bit earlier, you're going to have people who were used to taking work home, who were used to staying late, and that sort of thing, who are no longer going to be able to do that. And there's going to have to be a way to fill that gap.
Do you know when the Department of Labor will publish the official rule and documentation?
The official rule is actually published. The DOL has a little write-up on their website, including some frequently asked question type things, and then there's a link to the Federal Register that has the full rule up, discussing everything. It's lengthy, to say the least.
Well, if you're looking for bedtime reading, maybe you're part of the Insomniacs RS, we'll publish the link for you. And so if you want to take a look at it, look at the list of frequently asked questions over on the transcript of this podcast. We will do that for you.
Yeah, I would recommend definitely at the very least taking a look at the fact sheet that they have put together. It summarizes the changes pretty well and will give you a pretty good indication of exactly what is coming at you.
Casey, thank you for joining us today. Where can people go to learn more about you, or how do they connect with you if they have more questions about the changes upcoming with the FLSA?
Sure, you can always head over to my blog, The Employer's Lawyer. I'm also on LinkedIn. You can look me up, Casey Sipe, and you can find me on Twitter at CLS Employer Law. Send me a DM, tweet at me. That's generally a really good way to get a hold of me. I'm almost always online in some way, shape, or form.
Well, thank you, Casey, for joining us. And thank you, the listener, for checking out the Workology podcast today, where we discuss the science and art of the workplace, HR, and recruitment. This is Jessica Miller-Merrill. Until next time, you can visit Blogging for Jobs to listen to all our previous Workology podcast episodes.
Production services for the Workology podcast with Jessica Miller-Merrill provided by TotalPicture.com.